Good morning. We'll start in the next 2 minutes. Can I request the speakers to join me here, please? I think the Thai speaker is also here.
Yes. You can mention the parallel sessions.
The what, sorry?
The parallel sessions, because I was just asking if they can choose if they want to choose. Yeah.
Would you like to make an announcement? Thank you, Matthew. That was a difficult choice, air or water. They said if you don't breathe like, no, not they said, we all know. If we don't breathe air for 5 minutes, you die, or maybe a bit more. But if you don't drink water, you can survive at least definitely more than an hour. So I hope, I'm not saying air is more important, both are important. All right, no, thank you. Good morning. It's a pleasure for me to moderate this session. I am Bert Fabian. I'm a coordinator of the Secretariat for the INET. It's an acid deposition monitoring network that was established more than 20 years ago in 2001. At that time, we all know about this issue of high sulfur dioxide emissions, coal having high sulfur, our fuels for transport. So acid rain was very important. So many countries in East Asia, 5 countries in Northeast Asia, and 8 countries in Southeast Asia joined together to see how to understand this issue better and how to help the government officials address this issue. So INET has come a long way. It has contributed to reduction of sulfur dioxide emissions leading to acid rain. And it has also helped in training government officials in our region. But of course, this issue of air pollution, as we all know, is very complex, very difficult. I have been involved myself over the last 20 years on issues on transport, policy development, other issues on air pollution. But honestly, I've never been involved in any litigation cases or any legal cases pertaining to air pollution. As such, this session aims to address this urgent need for legal measures or the use of legal measures. And it will explore innovative legal strategies, regulatory and policy frameworks, as well as community-based initiatives to support better air quality activities initiatives. And it will also look into this intersection of law, policy, and public advocacy. We have 1 hour and a half for this session. We have 3 very good speakers. We are slightly delayed, but I think we will have enough time. If the speakers also would like to limit their presentation to 15 minutes, then we can have questions and answers also, more interaction from the floor. Before we start, perhaps let me just introduce now our speakers. You have met and seen Renee Gift. She is my colleague and UNEP legal officer based in Nairobi. She has 14 years of experience working on legal issues at the national and international level. And she worked on issues on air quality, climate change, and also ozone-depleting substances and fluorinated gases. Before UNEP, Renee worked with the Intergovernmental Hydrological Program of UNESCO, WATER, and also looked at cooperation on issues on shared water basins. She is a lawyer and has, how do you say that, passed the bar in Trinidad and Tobago. Okay. Our next speaker is Bella Natania. Maybe she will have a lot of stories to tell us. the past few weeks, air pollution in Jakarta is very bad. I think it is ranking as #1 in the world. Bella, she is a researcher and environmental lawyer at the Indonesian Center for Environmental Law. It's based in Jakarta, and it's help in developing law and good environmental governance in Indonesia. She has worked on air pollution, water pollution, and waste issues. But from 2019 to 2021, Bella was part of the team in Jakarta, or together with the citizens, that for the Jakarta Air Pollution Citizen Lawsuit that sued the president, the ministers, and governor of Jakarta for negligence. So we will hear more about this later from Bella. Our last speaker later, but not the least, is Wachalawaki Kumbunrong. She is a freelance lawyer. I'm sorry if I'm not pronouncing your name properly. Okay, so thank you. She is an independent lawyer and researcher, and she has worked on this PM 2.5 case in Chiang Mai province on this lawsuit, and also the lawsuit to revoke the unlawful environmental impact assessment of Omkoy coal mining Omkoy coal mining in Chiang Mai. And she has also run an academic journal paper on environmental and climate justice if you want to read more about her work. She's also a practicing lawyer and a faculty of law in Chiang Mai University. I think I stop here. Maybe our speakers could also say more about themselves, but I would like now to call Miss Renee Gift to give the first presentation. Renee, thank you.
Thank you, everyone, and it's a pleasure and honor to be on this panel to discuss air quality. I know many of you were here for the first session, so actually you would have seen most of the points that I'm going to make today. But part of why I wanted to be on this session was because, as you know, we've just launched our guide on ambient air quality legislation, which is a bit different from litigation. I mean, it focuses on national guidance for developing air quality laws and regulations. But what was very interesting is that we did feature, in some cases, litigation in countries that helped to define provisions of the law. So throughout the guide, it was noted where perhaps some provisions of legislation in some countries, to better understand them, there was litigation from countries that was illustrated. We won't go into them too much today, and actually the focus of the presentation is really on the guide and the principles. So hopefully, I'll try to summarize, but at least for those online, if they haven't been able to see the presentation before, this could be useful. So I just first wanted to start with the global assessment of air pollution legislation that we did in 2021. This was the first publication by the Law Division on Air Quality Legislation, and it assessed, or it looked at legislation from 194 countries and the European Union against what we developed as a model for robust air quality governance. This was developed as part of the research, but it looked at how, not whether countries were actually in compliance with their legislation, but it looked at just how the legislation was structured and whether there were consequences that were established for failure to meet them. And as with the guide, it centralized the whole understanding of air quality legislation around ambient air quality standards, which both that report and the guide consider to be the bedrock of robust air quality governance system. So I just wanted to quickly go into some of the findings of that report. Again, this was based in 2021 on the pre-2021 WHO ambient air quality standards, but I think it's very illustrative of sort of some of the gaps and the challenges that exist in air quality legislation in the region. So it was found that 66% of countries had ambient air quality standards set in a legislative tool. And so this was important. It was a good sign, since it's a good sign that provisions provisions embedded in air quality legislation impact the government's obligations to monitor air quality and to take measures to respond to legislation when it's been violated. However, there was a low compliance with WHO air quality guidelines in the pre-2021 update, with only 2 countries having air quality standards for PM 2.5. And only 10 out of 38 countries had ambient air quality standards compliant with the pre-2021 ambient air quality guidelines for NO2. So there was a lot of work that needed to be done there, and a low number of countries, as you can see, had legal duties on governments to meet ambient air quality standards, which obviously impacts whether these standards can be met or are being met if there are no consequences, if there are no requirements for governments to take action, and there are no requirements for governments to actually develop plans to achieve ambient air quality standards. And then, as you can see, there were more or less average legal rights established to access air quality information by the public, but low levels of rights in public participation in setting and developing air quality standards and monitoring. And this and the guide notes that public participation in both developing the standards and receiving information about air quality is important. It was one of the most important factors to contributing to a robust air quality governance system. 15 out of 57 countries in the region had some legal requirements mandating policy coordination for air quality. And we'll discuss a bit later on that administrative frameworks that actually coordinate the different sectors and the different institutions on air quality is extremely important, and a very low number of countries had legal provisions for transboundary air pollution, which was mentioned on Monday. And in total, globally, only 63% of countries did not have any provisions at all. So with that backdrop, we focused both the assessment and the guide on legislation, because we believe this to be a very important mechanism in air quality governance. Actually embedding processes to review air quality standards and plans and to create consequences for failure to meet them is an important part of managing air quality and managing air quality pollution. The guide also indicates that legislative processes were selected as an important mechanism because they are well adapted to the problem of air pollution, which is a collective, cross-sectoral and evolving problem, which requires constant review and update, and also balancing of socioeconomic priorities. And of course, enforceability is important. Without this, it's difficult to ensure that the air quality standards in law are being met. So yesterday I also talked about the guide on ambient air quality legislation that we produced in a couple months ago, and this built on the findings of the first assessment report on air quality legislation. So it translates the findings of that first report into concrete questions and considerations for lawmakers. So this guidance material is really targeted at lawmakers globally. They highlight key questions that lawmakers should ask themselves and key considerations when developing air quality legislation. It's broad enough so that countries in many different types of situations may be able to apply those principles to their national context. And of course, it's targeted at countries seeking to either develop new legislation or improve the legislation that they already have. And it's really focused on, around air quality, ambient air quality standards. So a quick introduction to the structure of the guide. Many of you may have already seen it. It's available online, but it is contextualized around many different areas of air quality legislation, the global context for setting national standards, enforcement and compliance provisions, administrative frameworks. It's set out in a way that readers aren't necessarily expected to read it from the first page to the end, but you select more or less where you might have needs, and you can go straight to that chapter. So as you can see, we talk about compliance, procedural rights, and coordination. So the global context for setting national air quality standards informs how countries should tailor their legislation. And what we suggest in the guide is to look at the WHO air quality guidelines as a foundation, as they are, especially in the absence of an international treaty, they provide an authoritative global reference of evidence underpinning a need for ambient air quality standards. And it's a good starting point for countries to set their own ambient air quality standards. Below that limit, it's only moderate public health benefits are likely to accrue. So just looking at some initial key considerations when developing a national air quality law, the guide suggests we look first at the purpose and the objectives, as the objectives can really set out the focus of regulatory attention and the ambition that countries, that the rest of the following legislation and regulation should follow. Countries should consider the scope, whether it also considers indoor air pollution. The initial assessment report found that most countries did not address indoor air pollution in their air quality management law. And so this is something that should be considered, whether it should fall within the scope of this law. And public participation provisions, as we mentioned, the access to information, the ability of the public to participate in the development of the standards as well is something that the processes for that should be considered as well. And then which pollutants should the ambient air quality standards regulate? And this obviously depends on the unique country context. In developing administrative frameworks, it's important also to look at setting standards. And again, we talked about whether the standards should be based on WHO air quality guidelines, and it was suggested in the guide that they should. Embedding mechanisms to review over time air quality standards is an important part of this administrative framework as well. In terms of monitoring, I had mentioned that monitoring is one of the most important requirements in an air quality law, because it should be embedded in legislation. And usually this requirement is imposed on the state, since measurements from individual air quality operators are not likely to be representative. Importantly, it should assign responsibility to specific institutions or bodies to undertake the monitoring. And this should link with obligations to disseminate data as well. So almost second to last slide on compliance and enforcement measures. And I wanted to mention this because I think anytime we talk about air quality legislation, or that I've talked about it, people always say, well, the problem is not having the legislation, it's enforcing it. So this is one of the most important parts of a robust system of air quality governance. And it means that legislative regimes should set out the consequences if ambient air quality standards are not met. If reliable data demonstrates that AAQS are not being met, there should be legal consequences for this breach of law. The exact nature and form of the consequences will depend on how legal breaches are resolved in legal cultures, but they also depend on how legal consequences are defined in the legislation itself. So some tools that can be used as consequences are obligations that require an administrative process or administrative process to be set in motion to develop detailed actions for the achievement of ambient air quality standards. Countries or users or citizens need to understand what standards they should meet before it can be enforced against them. So it should also, a useful device also is to ensure that information about air quality is public, so that it can be transparent and citizens and users and people in society can also know whether a standard is not being met. Another important part of ambient air quality legislation or management is setting in place key principles for coordinating. So this includes policy and regulatory alignment across different policy areas. So it might be different industries, for example, transport, businesses, and so on. And both horizontal and vertical coordination measures need to be considered. So across the same level of government or linking different levels of government control. And of course, mechanisms should also be developed in a gender-sensitive manner. So I just quickly also wanted to mention a couple other cases that were mentioned in the report and how this has to do with how this influences the development of legislation as well. They're not from this region, but they were very instrumental in understanding or influencing the interpretation of legislation. And one comes from South Africa, where it was found that poor air quality, the court found that poor air quality in a certain area breached residents' constitutional right to a healthy environment. And it ordered the urgent improvement, management, and maintenance of the air quality monitoring station network to ensure that verified, reliable data was produced. So you see how, both how an embedded right within the law can create obligations on the state to take certain measures, and the court can make very pronounced declarations as to what kind of measures the state needs to take. And in Brazil, the court actually denounced the unconstitutionality of a resolution establishing ambient air quality standards because it said that these standards were too weak to give sufficient protection to the constitutional right to a healthy environment. So in these cases, these claims were centered around an existing constitutional right to a healthy environment, but it is, and they were, although the guy didn't focus on litigation, it really demonstrated how litigation and courts can really play a very important role in outlining the obligations of the state and also fulfilling human rights. With that, I thank you for your attention.
Thank you very much, Renee. Definitely an important issue. Standards, it's the basis for the legislation. All of the countries that are in here have the standards. And I'm sure it's all based on WHO. But maybe the question is, what happens if we continually do not meet the standards? And these are standards set by the governments, national governments as well. And it can be lax, it can be strict, but the standards are there. So what do we do when the standards are not met? There are many, and in this session, maybe our colleagues will try to answer this in these litigation examples. So now we will have Bella from Indonesia Center for Environmental Law. Bella.
Thank you, Bert. Good morning, everyone. Maybe several of you in this room already heard about my presentation 2 days before, but these presentations will take a pretty different angle from the first one. So I will mainly talk about the Jakarta air pollution litigation that happened during 2019 to 2021, and currently it's still ongoing right now because the government appealed to the decision of the district court. So it's still an ongoing case. So my presentation itself will be separated into 3 different parts. The first one is the background of the lawsuit, and the second one is the lawsuit itself, and the third one is the impact that gained after the lawsuit. So to be brief, the first one, as you can see in here, you can see a marathoner, a runner in this picture, because during Asian Games in 2018, actually the air quality in Jakarta was really polluted at that time. So there was a lot of news in the newspaper that said that the runner record, the time record is not really that good because the influence of the air pollution in Jakarta. So they cannot get the best record time during the Asian Games because of the air pollution in Jakarta. And during that time, we get traction on our campaign because of the Asian Games. But actually, if we try to track back on the research, it already said before that Jakarta is really polluted since 1997. So the first research that stated that Jakarta is polluted is since 1997. And it becomes worse, of course. And during 2016, it got worse and worse until we tried to petition the lawsuit in 2019. So there wasn't many change since 1997 until 2019 when we petitioned the lawsuit. And then in 2018 and 2019, the impact of air pollution is also impacted a lot of communities because during that time, we also had this very long dry season. That's why during that time, the air pollution becomes really bad and impacted the communities in Jakarta. So as you can see in here, the PM 2.5 pollutions in Jakarta during 2018 and 2019, and the right one is the unhealthy, and the orange one is unhealthy for sensitive group, as you could see in here. It's an index from the US Embassy, but as you can see in here, that there is many red days in 2018 and also 2019. As you could see also in here, this figure will show you that the WHO recommendation, we are beyond the WHO recommendations on annual average. As you could see on the chart below, on to PM 2.5 and also ozone, we also beyond the national air quality standard, even beyond the WHO standard. Maybe you already saw this figure before, but this figure really emphasizes the impact of transboundary air pollution in Jakarta. So we are surrounded by industry, coal-fired power plant in Jakarta. And as you could see in here, so the Jakarta is the capital city, but in the neighborhood city, there are several provinces, like 2 provinces. The first one is West Java, and the second one is Banten province, which make it a little bit tricky for tackling the air pollutions because there are 3 separate administrative areas. So if we try to look it back, actually these 3 separated administrative areas should be in one airshed and also have one air quality management plan to address the transboundary air pollution. But that's not the case because during 2019, we don't have that law that really address the transboundary air pollution. That's why we filed the lawsuit in the first place. And then as you can see in here too, so the major source of pollution in wet season and dry season in Jakarta is also pretty different. Still, the vehicle exhaust is the highest one, but there is also a coal combustion during the wet season, and also sea salt even during the wet season. So it's pretty interesting because you don't see the sea salt, for example, during the dry season. This is from the emission inventory that happened in 2019. So because of the air pollution, 32 plaintiffs sued the government in 2019 because of their negligence in performing their obligations in the regulations. And this negligence led to Jakarta air pollution. So our plaintiffs comes from a very diverse background. There is even a motorcycle vehicle taxi driver, and also a mother who her daughter impacted by the air pollution, and also there is a business person. So it was a very diverse, because as you could see that air pollution not only impacted several communities, but all of us is impacted by the air pollution. So we use the citizen lawsuit mechanism to file this lawsuit during that time. The impact when we choose the citizen lawsuit mechanism, we could not ask the court to give us compensation for the air pollution. So we could only ask them to change the regulations, to push the government to do their obligations according to the regulation. So no compensation. So these 32 plaintiffs didn't receive any compensation after they win the court decision in 2021. Next, so we got 5 defendants and 2 co-defendants. The first one, we got the President of Republic of the Indonesia, the Minister of Environment and Forestry, the Minister of Internal Affairs, Minister of Health, Governor of Jakarta, and also because of the transboundary nature of air pollution, the plaintiffs also sued the Governor of West Java because they are the neighboring area in Jakarta that has many factories, industries, coal-fired power plant, and also Governor of Banten. The first one, we sued the president because of his negligence to fulfill the human rights. For example, the rights of healthy and clean environment, and also right to health. And then the second one, we also try to make him to revise the air quality standard according to the WHO standard, because the first standard that they established is from 1999, which is 20 years before we filed the lawsuit. So they were trying to revise the air quality standard between 1999 and also 2019. So during the 20 years, they were processed. They have a process on that, but they haven't established because of the political condition and so on. And then we also try to make them to enact a provision on the transboundary and air pollution. For the Minister of Environment and Forestry, we try to sue them because they are negligent to supervise the emission tests conducted by the local government on the mobile resource, aka the vehicle. For Minister of Health, we want them to do research on the impact of air pollution to human health, and also communicate the impact of air pollution to the public. For the Minister of Internal Affairs, supervise Governor of Jakarta, Governor of West Java, and also Governor of Banten on the transboundary air pollution issue. And the final one, the Governor of Jakarta, we asked them to enforce the emission tests on pollution source, both on stationary source and also the mobile source, and also provide sufficient air pollution monitoring system, because during that time, in 2019, we only have 5 air quality monitoring system, which is not sufficient for the area and the demographic of Jakarta. At least according to the research, we have to get at least 30 air quality monitoring system. And also, we need them to do the emission inventory, because during that time, there weren't any emission inventory that have been done by the government of Jakarta during that time. So after we petitioned the lawsuit to the court in 2020. Finally, they get their own emission inventory. Like I've said to this forum before, emission inventory is really fundamental to establish how we try to tackle, how we try to answer the air pollution issue. And also we asked them to create an air quality management plan and finally coordinate with the governor of West Java and also governor of Banten on the transboundary air pollution issue. And the impact of air pollution in Jakarta is, I could say that it's prevalent, both on the long-term and short-term health impact and also economic impact. For the long-term health impact, as you could see in here, the annual exposure to PM2.5 causes about 6,100 cases of stunting, 330 infant deaths, 700 infants with adverse birth outcomes, as well as nearly 9,700 premature mortality. This one is not the data that we used to file the lawsuit. This one is from 2023, but the impact is still the same. But during this time, in 2023, even they can capture the impact better than when we filed the lawsuit in 2019. And also on the short-term impact, the daily exposure to air pollution was associated with over 5,000 cases of hospitalization in a year. Most of them admitted to the hospital because of pneumonia and cardiovascular. And finally, on the economic impact, the total cost per year of the health impact from air pollution reached approximately $2,943 million, equivalent to about 2.2% of Jakarta province budget in 2023. Next, so in 2021, the district court decision the judge have found that defendants, so the president, the Minister of Environment, the Minister of Health, the Minister of Internal Affairs, and also the Governor of Jakarta, liable for the poor air quality in Jakarta. The interesting part is the judge emphasized the importance of science-based policy to counter air pollution. It was an interesting case, I think, to follow because not many environmental cases will have this kind of back and forth science data during the process during the process of the lawsuit. But this case, we exchanged a lot of data with the government during the process, which make it super interesting. And then but I need to underline too that, as you could see before in here, we tried to ask the president to fulfill their rights for healthy and clean environment, but the judge's reluctance to decide that the president is liable for their negligence to fulfill the human rights. So we think at first this happened because we have a specific human rights court in Indonesia. So this one is district court, and we have another specific human rights court in Indonesia. Maybe that's why they feel reluctant to decide that the president is liable for their negligence to fulfill the human rights. And the final one, I'm sorry, I need to add that until now, the president, the Minister of Environment and Forestry still appeal to the High Court, and the High Court established that they are liable for the poor air quality in Jakarta, but after the High Court decision, they try to appeal again in the Supreme Court, and the case is still going until now. And final one, my final slide. There are a lot of change made by the government during this after our our lawsuit. Even during the proceeding and after the court decision, the government made several changes to counter air pollution in Jakarta. The first one, the president tried to establish a better air quality standards in 2021, even it is not in there. It is not similar with the WHO standard guidelines in 2020, the new one, if I'm not mistaken, or 2021, but still, there is a big improvement from the government. And the second one is they also add the provision on transboundary air pollution in the regulation, in the government regulation, which make it easier to address the transboundary air pollution issue in these current years after they try to establish the provision. For the Ministry of Environment and Forestry, they supervise the implementation of emission tests on mobile sources, and they do it they start to do it in this year. They try to supervise how the governor of Jakarta implement the emission tests on mobile sources. And they also add PM 2.5 on their air quality index. So before, they don't add PM 2.5, only PM 10. But after our lawsuit, they try to add PM 2.5 in the air quality index. And currently, together with ISIL, they are working to develop regulations on air quality management plan, which is the foundations of the management on air pollution. And the Minister of Health also established Committee for Respiratory Disease and Impact of Air Pollution, also in 2023. And the final one, the Governor of Jakarta, they developed emission inventory in 2022 and developed roadmap to improve air quality in Jakarta in 2022, enacted regulations on mobile sources, and implement the emission tests also on 2022 until 2021. And the final one, coordinated with neighboring province, start on 2022. But what I need to underline in here, they start the coordination in 2022, but during that time, we don't have the regulations on transboundary air pollution. So they try to make a memorandum of understanding with the neighboring province, but it is not really effective because we don't have the transboundary air pollution provision during that time. So when the transboundary air pollution provision enacted in 2021, it becomes more clear to coordinate between the governor of Jakarta, governor of Banten, and also governor of West Java. I'm sorry, I need to back a little bit on the regulations on mobile sources. While in 2021, they already try to implement the regulations, but until now, they're still tinkering how to implement the sanction on the mobile sources owner or driver, because there are several different organizations that entangled in the regulations on mobile sources emission tests. For example, the police and also the Minister of Transportation, which make it hard to establish the correct sanction to implement this regulation. And the final one, though there are many changes made by the government, still the implementation, we need to keep pushing them to do the implementation, because until now, like Bert already said before, we're still the most polluted city in the world. And even the president before in the news said that he has been coughing for like 4 weeks because of the air pollutions. So, it becomes a more mainstream issue, but still a lot needs to be done. And I will end my presentation in there. Thank you.
Thank you very much, Bella. That is very interesting, and I'm sure Many of you have questions, as am I. I think truly your civil lawsuit on air pollution in Jakarta would have lasting and transformative impacts, or we hope, right? But before we go into questions, let's now hear from Wachalawali from the case of Thailand, please.
Hello, everyone. As I listen from the Jakarta case, which is quite similar and the same problem in Thailand also. So this is quite surprise for me to know about it. And before we start, I feel honored to join this panel and be a representative of Thailand PM 2.5 litigation. First of all, I would like to thank Right International organization to support me for this opportunity and talk about this case. And we could not have done a litigation very smooth like this without help from law, CPCR, and CRC. Before we jump into the detail of this case, we have two lawyers, me and Khun Kornkanok Wattanaputi, who sits in this room and will help to answer those of questions also. And for this case, we have a few days to preparation. We do the case for 10 days and file to the administrative court. And please allow me to show you about Chiang Mai province. We live in the northern part of Thailand, surrounded by nature and fresh air. However, in past 2 decades, the ex-province in northern Thailand have been facing with air pollution and PM 2.5. So as you see in the left-hand side picture, it happened in 2019, which is very severe, heavy air pollution of PM 2.5, and then this year on March, on the right-hand side, we're still facing and suffer with it. So from 2019 to this year, Thailand have been 5 cases against government agency like the Prime Minister and the National Environmental Board, asking them exercise their power given by the law to mitigate air pollution, resolve and prevent it. It has been shown that Thai people, especially on northern part of Thailand, suffer from the severe health impact from PM 2.5 every year. This is our poster that we used to campaign with the public space, and we got a lot of support from this. The reason we bought the litigation because of, firstly, northern people has suffered from PM 2.5 in everyday life. During January to April, the level of particulate matter in the air existed more than 100 micrograms per cubic meter and continuously more than 3 days. And we live with it like a month or maybe 2 or 3 months, which harm human health. The maximum was up to 974 micrograms per cubic meter. Secondly, there are reports from the Public Health Department reporting the number of patients from air pollution during January to March this year was up to 1.3 million people. And lastly, the northern people were not only affected by the air pollution within our border, but also transboundary haze from neighboring country. Greenpeace Thailand conduct a research which conclude that 1 in 3 hotspots within Mekong sub-region were located in industrial scale maize field, and the explanation of maize for animal feed farming by Thai transnational agro-industry was the primary contributor to the seasonal haze in the Mekong sub-regions. So for our case, was filed as the Chiang Mai Administrative Court. We sue the government agency because their duty under the laws and can provide sustainable solutions. Otherwise, if we were take the litigation to the civil court, it will solve a problem on case by case. We need several resources to prove our case according to the burden of proof principle. So we choose the administrative court and we brought it to on April 10 this year with 10 plaintiffs who are Chiang Mai citizens, such as law lecturer from Chiang Mai University, medical doctor, environmental activist from Chiang Mai Beach Council, Northern Beach Council, Balance Chiang Mai, and local people, including adults and child, 14 years old, together with 727 supporters signed in person and 1,000 people in online. In addition of the petition, we used national laws and international human rights law to claim our rights to be healthy in environmental. And for the defendants, we divided them to two groups. The first group consists of the Prime Minister and the International Environmental Board, as they are the national mechanism because they are fully authorized by the enhancement and conservation of the National Environmental Quality Act 1992 and the National Action Plan on Haze 2019, but they are neglected official duty required by the law to be performed or perform such duty with unreasonable delay. The two other defendants are the Security and Exchange Commissions and the Capital Market Supervisor Board. Because of we facing with the trans-boundary haze, so we seeking the state mechanism or law to enforce the business sector to disclose human rights risk information to their supply chains, whether they operate in Thai territory or outside territory. Additionally, these regulators have the duty to respect the United Nations Guiding Principle on Business and Human Rights to encompass protecting human rights to business supply chains. Also, recently, the stock exchange issue has a regulation on a new annual report form called One Report that forced the listed company to disclose social risks and environmental risk information to their supply chains operations and report back to the stock market. We hope this mechanism could affect the listed company that relate to burn agro products, which was a source of trans-boundary haze, to stop or at least become more awareness on human rights perspective, as well as we wish the power of market force from the shareholder who respect human rights to be a part of problem solving. And for the request to the administrative court, we have three main issues. First, the Prime Minister and National Environmental Board have to exercise their duty by the law to mitigate, solve, and prevent PM 2.5 situation in the northern part of Thailand. Second, the NEB have to revise the HAZE National Action Plan 2019 to achieve the air quality standard according to WHO standard. Third, the SEC and CMS have to define measure, condition, and method to review information in the form of one report to enforce the listed company to disclose human risk to supply chains, whether operate in Thai territory or other territory. But for now, our case is still on the courtroom. So I will update the situation. On April 20, the Chiang Mai Administrative Court accepted the case but dismissed the petition of SEZ and CMS with the reason that they are not the government agency who have duty under the Enhancement and Conservation of National Environmental Quality Act. So we decide with the plaintiff that we will appeal to the Supreme Administrative Court on May 18, and recently, on July 11th this year, the Supreme Administrative Court accepted to consider the petition of SEC and CMS. And due to this case, we face a lot of challenge about the air pollution. We found that in Thai territory and the transboundary I will start with Thai domestic law first. In Thai constitutional doesn't recognize the right to a healthy environment, and we also don't have clean air laws such as the Clean Air Act, Climate Change, or PRGR Act to control the problem of the air pollution directly. We hope the new government will work on this act as they promised before the general election. And however, for the transboundary issue, there are many ways that Thailand could create prevention mechanism to solve this problem, such as for Thai investors who run the businesses in other countries but bring the haze pollution back to Thailand. The government must have the corporate accountability or extraterritorial obligation regulation and the mechanism in the territory to support the rights to access justice and remedy for injured groups. Also in the climate change era, the transboundary pollution has a severe impact and poses big challenge to ASEAN regions, not only Thailand. Even though there are ASEAN agreements on transboundary haze pollution, but the problem of PM 2.5 is very serious now. How do we prepare for this challenge and find sustainable solutions? Thank you for your attention.
Thank you very much, Wachalawali. That's also very good, comprehensive presentation. All the best and good luck to you. But now I think we can open the floor for questions or comments. If you have, for the country representatives also, you can turn your name tiles if you want to speak. Yes, please, sir, from our colleague from Bangladesh.
Thank you for the issues relating to climate change, and thank you all the three presenters for their excellent presentation, which is very relevant for many countries, especially for Bangladesh, for Dhaka city also. In many cases, Dhaka city become first in air pollution, so it is very relevant and important for us. And we have come to know under the study by the World Bank that around 30% air pollution in Dhaka city from other countries, not from the other cities, from other countries. So I have first question to Reni, that you have mentioned that 9 countries have the legal provision for transboundary air pollution. So if is there any provision on the guide that relating to transboundary air pollution, that how country can incorporate in their national legislation the transboundary issues, whether it may be the inside from the country or from the other countries? And second, question to Bella on the issues that aqueous air quality standard that is in 2021, and that introduces the provision of transboundary pollution. So can you please mention it elaborately that how it is incorporated in the legislation of your country? And thank you.
Thank you very much. Maybe we take one or two more questions, comments from the floor, and then we ask the speakers to respond. Yes, Matthew. Sorry, I also need to acknowledge that we have participants online, right? And if there are questions, please tell us, Matthew.
Thank you very much. And so this is a question from me rather than online, but we're monitoring. And really it's to a bit to Renee, but also commenting on solutions. And I think the recent report on ambient air quality is excellent because it shows that there are mechanisms to identify how you can include ambient air quality in regulatory standards, but obviously they then need to be complied with. But as someone who's worked on air pollution for a while, I also really want to just acknowledge and mention that the Beijing experience on trying to address air pollution, and in my view, it's the only city or large city in recent memory that has actually been able to respond to certainly urban air quality issues. And that was an extraordinary contribution and commitment from all levels of government and the community. I mean, they installed over 1,000 air quality monitors throughout the city. They spent significant sums, and I think that's also one of the problems with air pollution is that these things cannot be solved very quickly, but they require a significant commitment from governments to acknowledge, I think, the very, very real health consequences. And I think some of the work from the WHO makes it clear that more people are dying from air quality and poor air quality, especially young children and the elderly, than died during the COVID pandemic. And we know how we responded to that. So we really now need to respond to the air pollution pandemic in the same way. Thank you.
Thank you very much, Matthew. We have a colleague, a representative from the Philippines, please.
Thank you so much. And I appreciate the presentation of the cases, actual cases from Indonesia and from Thailand experience. The Philippines also has had several cases involving these novel issues, which were, after the cases, were incorporated in our policies. And I am talking about the cases demanding the government to act pursuant to its mandate. And that case was very challenging as well with your experience. And my question is on the aspect of how much legal posturing or basis did you put in the petition that will make the Supreme Court or the courts favor your case? Because in the Philippines, there were cases that it was not yet in the law, but it was made the basis of the petition. That's why there were cases that were acknowledged worldwide because of what we call judicial activism. The Supreme Court had this relaxed the rules on the locus standi, or the standing to sue, wherein now we acknowledge representation from the minors and generations yet unborn, that intergenerational responsibility. We also have that novel recourse wherein the Supreme Court issued this continuing mandamus, requiring the governments to clean up a certain area, the Manila Bay area. And the implementation of that decision takes a while. So other issues as well. The Supreme Court of the Philippines also issued the guidelines on the writ of kalikasan to address violations of the constitutional rights to environment. So my question deals with the fact that how much legal basis was put in the petition that will require the courts to favor your case outside of the existing policies of your respective countries. Thank you.
Thank you very much. We will have next Pakistan and Nepal, but let's ask now the speakers to respond. But briefly on the comment of Matthew, the experience in Beijing definitely is a very good example. UNEP has conducted a review of this experience. There is a report online. It was published in 2019. We can share the link as well. But it is also looking into this Beijing, Tianjin, Hebei. So you can argue that this also involves these other boundaries or provinces outside Beijing, again, emphasizing this issue on transboundary. So let's go to the questions. I think we can start with Renee on the questions from our representative from Bangladesh.
Thank you so much for that question. And I mean, I know the answer, the guide features a couple examples from countries that have integrated provisions on transboundary air quality management. I know some of you were here for the presentation a couple of days ago, so it's a bit repetitive, but just to share with those who weren't here, there was one example from South Africa that was mentioned where it establishes a requirement on the minister to consider, or an obligation or the authority to consider transboundary air pollution that goes outside of the country. So that was one way to handle it, that an obligation to be aware and to take measures to mitigate the pollution that goes from your own country to another country. And then there was an example from Korea, which also required the minister to take measures to mitigate the pollution coming into the country. So it was just two different ways of doing it from two completely different countries and regions. And the point that was made was that these are not perhaps the best, I mean, they are a step towards managing transboundary air pollution that a country can take in their own national legislation. It won't completely address the entire problem because, as with all transboundary environmental issues, it requires cooperation among countries. But the important part of establishing these provisions in the national context is to give priority to it, is to assign responsibility for it, and just to ensure that it is something that is always considered in the management of air quality. And just a quick point in relation to Matthew's comment about the guide. I just want to say that, the guide, the importance of having a guide that breaks down aspects of air quality management into principles is just that I think, because like I mentioned in my presentation, when you hear about air quality legislation, sometimes the first thing that people, I guess maybe non-lawyers, say is that we don't want to hear about legislation. We just want, because legislation just exists, but then it's never enforced. And then the nice thing about the guide is that it actually breaks down, it's more than that. Enforcement of air quality legislation is not just about having provisions and enforcement and compliance, but there's so many parts of it, including setting an objective and air quality law, establishing authority to take action, establishing institutions that have responsibility, and setting administrative frameworks to ensure that sectors coordinate. And all of those things have to do with how well a country can enforce and monitor the laws and monitor compliance with laws. So it's not just, setting a penalty and, catching people in the act of doing it, but it's so many other things that that you may not think have to do with enforcement, but are so important to whether an air quality management framework actually works in practice.
Thank you very much, Renee. Perhaps, Bella, you can respond also to the question of the representative from Bangladesh on how, or if you can provide more information on this transboundary requirement for, like in Jakarta, West Java, and Bantan.
Yeah. Thank you, representative of Bangladesh, for the question. First one, I want to address that the Indonesian try to regulate clean air is not through a legislation. So we have this Environmental Protections and Management Act that covers water, air, soil, and other things. And the Clean Air the clean air regulations falls under this act, this big act. So it is not legislation per se, I think. And the second one, we try to regulate the transboundary air pollution issue by establishing several steps to address this issue. For example, you need to establish an emission inventory first, in the first place, to know whether this is to know whether there is a transboundary air pollution issue or not, and then try to establish the air quality standard, and then try to establish also the airshed or the air quality management area, and finally establish the air quality management plan. So if according to the emission inventory, the results says that the pollutions comes from the different province. It will become the authority of the national government to establish the air quality management area and also the air quality management plan. For example, if the pollutions comes from several different regency or cities, and it affected the whole province, it means that the provincial government who will have the authority to establish the air quality management area and air quality management plan. So in my opinion, when it comes to the higher government to coordinate the lower government, it makes it become easier to coordinate the whole air quality management and also protection. I think that's all from me, Bert. Thank you.
Thank you, Bella. I will ask next Wachalawali to respond to the question of our representative from the Philippines. But before you do this, I hope you got the question, but I'm not sure I really understand it. It's how much legal posturing or basis did you put into the litigation case? It's just like, I think, saying how much work did you put into it so that the court will treat it seriously, right? And that they will entertain this. Please, Wachalawali.
Thank you, the representative from Philippines, for this question. After the decade of the environmental case in Thailand, we take many years, and we take many years of the fighting from the environmental lawyer justice who bring the environmental case to the court, and the Supreme Court the Supreme Administrative Court had a lot of experience on environmental case, and some case we got a good decision from this fighting also. So after these fights, and for now, for the Administrative Court, they have their guideline on the environmental case, which is like our case. We have to complain our suffer to the government first, and then if they not do nothing, we can bring our case to the court. But we are suffer from the PM 2.5, and we not complain this to the government agency. We just bring it to the court immediately, and the court accept it. This is the result of that fighting that environmental lawyer fight before, and the court have a lot of experience on this. And for the air pollution case, we are 2 cases that up to the Supreme Administrative Court now, and we hope that the court will extend environmental justice to us again. I'm not sure that I answer you correctly or not, but I think the perspective of the Supreme Administrative Court, especially on the environmental case, we have a lot of good decisions from them, and they play the important role to protect the human rights and environmental rights issue in Thailand.
Thank you very much. Bella, would you also like to respond briefly?
Yeah.
I try to add a little bit on what my colleague from Thailand already said before. So to address the issue in the court, we try to prepare many scientific journals to establish our argument. For example, impact, especially on impact, how it impacted the health of the community, how many deaths that comes from the air pollution in Jakarta, and also the impact to the economic situation, both from 2019 and before. On the other hand, we also try to establish the argument about the air quality monitoring system, which is the governor of Jakarta didn't really provide the sufficient air quality monitoring system. And we got that argument also from scientific journals and data. Aside from that, during the court proceeding, we also try to invite many scientists as our expert in the court to make our arguments stronger in front of the judge. In the other hand, emission inventory on Jakarta air pollution also becomes a very important issue, and also data to establish our argument in the court. But I could say that it's very hard to have even one doctor to testify during the court proceeding, because I don't know why they seems to a little bit resistant, though it is really, I mean, the data is clear, right? There is a connection between air pollution and the impact on it, on the health. For example, the pneumonia, the cardiovascular, but still, you know, we cannot find a public health expert or doctor to defend our case in the court during the proceeding in the district court. But still, it takes a lot of scientific journals, and also I'm happy because the government also tried to argue back with scientific journals, with another scientific journals, which makes it a very interesting argument back and forth in the court. So I'm very happy during the court proceeding. Thank you.
Thank you very much, Bella. So you now have a PhD on air pollution. Our representative from Pakistan and then from Nepal. Please go ahead.
Thank you for your presentations. Very informative. We learned a lot. Litigation is definitely a very pertinent first step in a fight for climate justice. However, my question is regarding implementation. What are your expectations regarding implementation of any favorable decision which might be passed in your favor? Now, tackling issues like air pollution require innovation, technology, and transition to more sustainable practices, which is dependent on behavior change as well. So how do you suggest that these gaps are filled for effective implementation? Second, do you feel that regional cooperation mechanisms will be effective mechanisms where technology transfer, sharing of information, for instance, Beijing has been quoted as a great case study for combating air pollution. So maybe a regional cooperation mechanism, what are your thoughts on that, where we can just share information and perhaps get technology assistance? This, and finally, are there any suggestions regarding incentivizing data sharing when we're considering tackling transboundary movement? So data sharing data is very important when we're tackling transboundary movement of air. So how do we incentivize honest data sharing amongst different countries or even different states within a country, so on a national and an international level? So these are some of my questions. Thank you.
Thank you very much. Our representative from Nepal, please.
Namaste, everyone. Thank you for presentations. I think, did you have special experience while filing the, lawsuits in the court? Means, did you feel any threats or harm? If so, can you specify? Thank you.
Thank you so much. I also have a certain comments on the regard. Specifically, I'll give you a judge's perspective because from a Nepali and probably a South Asian viewpoint as well. In regards to the attribution of criminal liability to head of states, because I think that's very important in your case. If I'm not wrong, the president was also filed, was one of the defendant on the case that Bella filed. I suppose I'm correct, right? Okay. So the problem that judges usually face, and this is the question that usually law school also discusses upon, is that it is very difficult to attribute the environmental happenings to a certain single institutions. And the difficulty usually arises due to one, that there is this habit in South Asia as well, and particularly in Nepal as well, where many writ petitions that are only done for the sake of public taking the spotlight from the public, they tend to file litigation to many stakeholders which are not even relevant. So due to that, the court usually tries to look at different elements on it. Particularly, I'll give a reference to International Court of Justice, ICJ decision on Nicaragua v. United States, 1986, Justice Oda's opinion, Congo case, Wall opinion case. These cases have certain elements to fulfill when it comes to attribution of criminal liabilities to certain institutions. Second, on that similar setting, one of the court cases of Nepal stated, I'll first state in Nepali language and I'll give you the statement. गरेका कामहरू हेर्दाखेरि असल मनसायले गरेको तर भन्न चाहिँ असल मनसायले गरेको भन्न नमिल्ने. Translated to English language, it would be translated as the action cannot be stated as action performed with bona fide intention. So judges in particular in Supreme Courts usually faces that to attribute environment-based criminal liability to a certain institution, a very strong attribution should be shown, which the cases that I refer to might help in the upcoming days. Thank you so much.
Thank you very much. Okay, maybe just one more question, brief, and then I will ask the representatives to respond, please.
Thank you very much for all of the presentation. As you know, that use consideration in air pollution lawsuits has gained significant attention in recent years as a means to address the impacts of pollution on young people and future generation. So my question regarding to both cases shared is that have you considered any youth issues related to your cases? If yes, please just explain a little bit how did you do that? Thank you very much.
Thank you very much. Okay, last, our representative from Vietnam.
Thank you. In Vietnam, since 2009, we have the standard of industrial emission. And then now we have the law, environmental, to control the air pollution, including the requires protection for air protection for everyone, control the industry emission, permit the emission, and the national and local air quality management plan. The inventory, the carbon dioxide, and the punishment in case of violence. But we lack of the control transboundary air pollution. So may you describe more specific on the content for the air transboundary pollution control for more detail? Thank you.
Thank you very much. Okay, I will ask first Renee, and you can cover some of the questions from the representative from Pakistan, also with respect to regional mechanisms, data and transboundary, and then, of course, some other responses for the other questions. But please go ahead, Renee.
So, thanks for those questions. I think on regional cooperation mechanisms, the question that was asked from the representative of Pakistan, and how has UNEP been supporting? So as you know, there have been a number of UNEA resolutions on air quality, and those really serve to refocus and prioritize the issue of air quality among countries. These resolutions have been developed by member states, indicating that they believe that air quality should be a priority for the organization. And based on that, we have been working in our many different programs to support or to develop guidance on air quality. In fact, within the Montevideo program, one of the first priority areas that was identified by national focal points was air quality, and the research that we have done and the publications developed in the last couple of years have been in alignment or to implement this priority. We have also been working on different aspects to support countries on transboundary air quality management. Of course, the final decision on whether countries would like to cooperate to manage air quality is a decision of that country. But we have been supporting, for example, in highlighting within the guide how national laws could support this, or sharing good practices from other regions that have been successful in establishing transboundary air quality management agreements, such as the UNECE region. And they have, and in fact, as taking an example from UNECE, they have established protocols to ensure information transfer, technology transfer, and so on. So I think that the best way to go forward or to build on this is to learn from the practice of other regions. And we're certainly happy to share more information about how we can enable that sharing and cooperation so that other regions can learn from that. And also to share what processes the UNEP has been involved in to support the sharing. For example, UNECE has developed a group that has been specifically created to share experiences from UNECE to other countries. And we hope to, and we sit on that group to share or to come up with suggestions as to how this platform could be useful and how countries could access it. In terms of, you were mentioning from the representative of Vietnam more detail. I think at the moment we haven't done, the information that we have on transboundary air quality in terms of the national context is what I mentioned before, from sharing examples from countries as good practices on how countries have integrated that into their national laws. At the international level, I can share more detail perhaps afterwards, because we are not, it's not necessarily within our mandate to support countries. I mean, what we do right now, as I mentioned, is we work with UNECE in sharing good practices, and we're currently working within the regions to support countries in understanding maybe what areas they would like to cooperate on and how that can be facilitated. So giving advice really on how coordination and management across boundaries can be done, supporting them if they decide that regional cooperation is something in their interest. So I can maybe share more information with you both on some of the initiatives that we're looking forward to in the future.
Thank you, Renee. So there are two things in this transboundary. Transboundary within the country, so that's clear to us, other provinces, etc. That you can do, the countries themselves. Transboundary on board across other countries, this is something that needs, it's a different matter altogether. The experience that was described is in the UNECE, called Convention on Long-Range Transport of Air Pollution. So in this case, there is cooperation with the countries in the EU to look at emission sources, emissions inventory, and how you can put in place policies to regulate this and eventually reduce it. We don't have that in Asia yet. There are efforts in intergovernmental bodies like the one that I coordinate with the INET, but it does not look at this specifically. There is a new agreement in Asia Pacific called the Regional Air Pollution Action Program, led by UNESCAP, and our countries are also part of this. And maybe this can become a venue to look at this issue on the transboundaries. there are a lot of questions that probably is not addressed for the question of our representative from Pakistan. It includes what are your expectations on implementation? How do you think we can deal with gaps? But maybe you can briefly respond, Bella, and also Wachalawali. And sorry, Wachalawali, in your response, I don't know if you want to react on the contribution from Nepal with respect to the attribution of the head of state, or whether you can sue the head of state. So we have a few minutes. I think if we stop at 12:10, we will not eat into too much of our lunchtime. Please, Bella.
Thank you. Very short response to representative of Pakistan. I think there are three keywords that can contribute to an effective implementation. The first one is budget, because it comes several times during our discussion with the government that they cannot really implement the air quality management and also protection because there are lack of budget. Because, as you know, for example, to establish an air quality management system, it needs a lot of budget, even to establish it, and also to do emission inventory. It also takes a lot of budget. So budget is very important. And the second one is also coordination, because the authority to cover the air pollution issue separated into several different agencies, government agencies. For example, that I've told you before, there are also the influence of police, even in to address the air pollution issue. So the coordination is important. And the final one is political willingness to address this issue. For example, we addressed the lawsuit in 2019, but until 2023, finally we got a serious attention from the government to address the air pollution issue. So political willingness is also important in this case. And to react to the representative of Nepal, the attributions comes to the authority of the president as the head of state to make sure and to supervise and also to create regulations on air pollution, which is the mandate according to our Environmental Protection and Management Act, which make it easier for us to gain attributions from and to establish connection between the impact and also the obligations of the president. And then the final one, to react to the representative from major groups of youth. Yeah, in the lawsuit, we consider youth. When we file our lawsuit, we have 3 of our defendants are youth, and we try to connect between the health impact of air pollution and also economic impact of the air pollutions to the youth during the lawsuit. For example, we in the lawsuit we also really emphasize the impact when students went to school during a bad air pollution condition that will influence the health of the youth. I think that's all for me, Bert. Thank you.
Thank you, Bella. Wachalawali, please.
Okay, for suing the Prime Minister, because of our case is harm the PM 2.5, harm the public interest. So that's why we should the administrative court, because in the Administrative Procedure Act, we can sue the government officer to this court, and the Prime Minister have duty on the enhancement and conservation of the National Environmental Quality Act, and they neglected official duty required by the law to perform such duty with unreasonable delay. So we can bring this legal claim to the administrative court and ask the court to force the Prime Minister to solve this problem. And for the for the question about youth engagement in this case, so after we campaign about our case to the public, and then some of parents, our plaintiff, 14 years old, she talked with her parent and she said, this is effect for our health, also for our generation as a child who live in toxic cities like this. And I want to engage this case as a plaintiff, so they contact us after know that, and we very happy to get her because she a representative of the next generation who will live in this issue. Thank you.
Thank you very much, Wachalawali. Before I call on my colleague Georgie Lloyd for housekeeping, I'd like to say a few words as well. This has been very interesting for me, and I will not summarize the discussions, but my takeaway is legal measures do work, apparently. We have examples in Asia as well. You will probably remember the case in Delhi, where the people sued the government to replace the diesel buses because it emits a lot of air pollution. So this happened in early 2000. Another example is the highly publicized case against a car company that was caught cheating on complying with the standards. This is high profile. I think all of us know it. But having said this, and I think, and even for myself, I have not seen a reference guide where you can find this collection of litigation cases and how it can support civil society, but also governments in pursuing such legal measures to improve air quality management. Maybe this is something, I guess, UNEP can also try to facilitate to compile in the future. But again, I think this is all wonderful. Thank you very much for our speakers, Renee, Bella, and Wachalawali. Thank you all very much.
Thank you very much, Bud. And so just before you head off to lunch, a couple of announcements. A few of the documents that were referenced during this last session, including a report on China air quality, the global assessment of air quality legislation, which is this document, as well as the global assessment on climate litigation, have been uploaded into the resource folders. So if you have not yet had a chance to scan the QR code to get the meeting documents, today's PowerPoints are also going to be uploaded and updated in those folders. Second announcement, if you have not yet received a lunch coupon, please come and find me and I will give you a lunch coupon. Please remember to give these back to the cafeteria cashiers because we get in trouble if we do not give them back. And the third announcement is that this afternoon there are going to be parallel sessions. So there will be a session in this room on defending the defenders. There will be a session in meeting room A as well. And so please do join the session in meeting room A if you would like to, or you can join the session in conference room 4 here. If you haven't got the agenda with the detail of the parallel sessions, it's available on the table outside. I think there are still maybe a couple of copies at the back of the room. There's also a QR code where you can scan and get a digital copy of the agenda as well. So please don't forget that all day today, all of the sessions, there are parallel sessions also in meeting room A. And we resume at 1:30 p.m. So we have a little bit longer for lunch. Thank you.